coming from Westchester. I have a few things I was going to go over first, so we'll talk about that. The first thing I'd like to do is I'd like to start the day with a little gratitude. Obviously, this type of an event does not go on without people pitching in. And we have an amazing staff, and I would just like to give them a little love. Randy, Erin, and Maureen Plainfield have done a great job. So why do we make this event mandatory for the company? Well, there's a couple of reasons. The first one is, I do not want to lose my real estate license. Secondly, I don't want you to lose your real estate license and your livelihood. And lastly, we want to be known as the most professional and ethical company in the business. So we're always seeking to raise our ethics and our professionalism, and this is certainly one of the ways we can do it. Last week, I unfortunately had to write you a troublesome email about thefts in the company. I hope that you all got my very strong, clear message that this is not acceptable. Small things are big. Theft is not acceptable. It is not our culture, and it's not what we do. I wanted to add something that I didn't put in the email, and that's in the past, we have had associates with struggles, and they have come to me, and we have always helped them, because that's our culture. That is what makes us a company of integrity. And I want to thank all of you who sent me texts and emails and Facebook messages supporting the ethics that you know that we stand for. So I thank you, and let's have a little applause for our efforts. The other thing I want to briefly touch on is safety. This week I had to send you an email about a very also troubling situation with a former customer threatening one of our associates. We take safety very seriously. One of the things that we did is we took the opportunity to photocopy our best practices that was come up from a joint task force of both market centers last year for best practices. I hope that you were given them today. I hope that you will all read them, and you will all adopt them and implement them in your businesses every day. Another thing that we're going to be doing over the next month is testing a safety app. I'm going to ask now for a few people from each market center, if you would like to be in the group to test the safety app, if you would raise your hand, okay? Randy and Erin are going to take down some names. Okay, keep your hands up. The idea is if the app works properly, one of the things that we already know might be a problem is in some of our northern areas where there's limited cell phone service, there might be a difficulty with a phone app. But if it does work, our hope is that we will purchase it as part of our technology package that you're already paying for, and we will have that available for all of our agents to use. Because safety has to be a top priority for all of us. Do you guys have the names back there?
Yeah, just 1 more second.
Okay, 1 more second. Hold them up for her. Okay. So in the meantime, there's a couple of people I'm going to ask to stand because I want to recognize them. They are my partners, and they are our other principal brokers, Karen Sacconi and Dulce Ferreira. Karen is out of our New City Market Center, and she has an office, a physical office in Pearl River in our business center. Dulce is, of course, out of Middletown. Karen is also the broker of record for New Jersey because we are licensed out of the New City Market Center in New Jersey. When I talk about coming to me today for different things, you can also go to either of these two ladies, and I want to thank them for their leadership and guidance. They handle a lot of questions during the year and give a lot of guidance, and we thank you for that. So any brokerage matters can always go to, there are 3 of us principal brokers that you can talk to. When we're going to be discussing law today, we're going to be discussing New York law. So I know some of our associates are licensed in New Jersey, so I want to make it clear that the law may vary there. So today is just about New York law. As a company, we now cover a vast area. We now cover Rockland, Orange, Sullivan, Westchester, Putnam, Ulster. We just out of Middletown joined the capital area region, which means we cover Albany, Saratoga, Columbia, Greene. For that reason, we have included, everybody should have gotten a list of all of the associates in each market center, along with their contact information and the areas that they cover. This way, it will make it easier for you to refer business. It's a real win-win for us if we keep our referrals within our own Keller Williams market centers. And we will be updating that at least on a quarterly basis, and we'll post it out. Next, I have a housekeeping item. I'm going to ask for your undivided attention for the next 3 hours for our speaker. So I'm going to ask that you please shut off your phones and not look at your emails. Because what ends up happening is people are distracted, the speaker speaks on a topic, and then when it's time for questions, there are questions on what the speaker has already covered. And we have a lot of information to cover today, and we only have 3 hours. So hopefully everybody's business can wait. I know my business can wait for 3 hours. So I just ask for your undivided attention for the next couple of hours. We will have time for questions. In the past, we've opened up questions during the whole presentation. We're going to do it a little differently today, again, because we have a lot to cover and we have a big room here. So after each section, our speaker is going to ask for questions, and at that point, if you can just hold it for each section, we will have a time for question. And now I see that our speaker has made it. So I'm going to introduce him. Our speaker is John Dalgetta. He is our corporate counsel and managing member of the Dalgetta Law Firm. Many of you are familiar with our beloved Ed Sumber. He has been my corporate counsel even prior to Keller Williams for about 20 years. Well, Ed is now basking in the sun in Florida for the winter. Ed is now of counsel with the Dalgetta firm, and he and John are very active in brokerage matters, including being counsel to the Hudson Gateway Association of Realtors and our MLS. John is a Pace Law grad, and he has a strong background in representing corporate clients in matters of contracts, e-commerce, real estate. John is respected within the brokerage community as a knowledgeable authority of brokerage law and has written numerous articles for Real Estate In-Depth, the HGAR publication, and Legal Lines, the NYSAR publications. So now I'm going to turn it over to John.
Told me when it turns green, I'm good. I believe that you received all of the course materials that probably all emailed to you. Yeah, just right there. Perfect. Okay. So good morning. Happy New Year to everyone. We start off the new year fresh. We're going to revisit a lot of the stuff that went on in 2015 mostly. Also some new laws that will come into effect as of 2016. So, as Rosemary said, I have been an associate with Ed Sumber since 2001. I became partners with Ed back in 2008, and we merged our practices. I took over his practice as of May of 2015. So Ed is of counsel to the firm. We've been representing the Board of Realtors. Ed's been representing the Board of Realtors for over 30 years. He actually incorporated the Hudson Gateway MLS back in 1976. So, and I've been basically taking over the reins on all real estate matters, corporate, brokerage issues, agency issues. So again, thank you. Welcome, everyone. And we have a lot to cover. So what we're going to try to do is we're going to go through each section. What I've done is basically there's handouts, there's some materials. I'm going to refer to the materials. You don't really have to go through it. You're going to have a huge amount of paperwork that you can refer to. It's a very good resource. So if you ever have a question, you can go through. There's a lot of articles, there's a lot of outlines, there's a lot of points that you can go through step by step and you'll be fine. And again, any questions, you can always direct them to Rosemary and then she'll direct them to us.
Yes.
So we're going to start off. The handouts on this particular item are attached. We're going to really just go into the advertising guidelines a little bit. That's our first topic. We want to focus on, and I'm going to just bullet point a lot of the areas. Obviously, you're going to have a lot of questions, so what we're going to try to do is at the end of each section, we'll try to open it up just for a few questions, because we do have a lot of materials to cover, and by the time we get done, believe me, we'll be lucky if we can get through the materials. But this is a good, like I said, a good resource. So even if we don't get, I'm probably going to focus on the most important items. If we don't get to some items, it's because they're just not important, but less important. So for advertising guidelines, business cards. A lot of people have business cards. I see business cards handed out to me every day, and right away what I do is I pick out what's wrong and what's right with them. So we're just going to go quickly through. A business card must contain the business address of the licensee, the name of the real estate broker with whom the licensee is affiliated, and must contain the office telephone number for the licensee or the licensee's team. So that's a lot of information that has to go on the card, but it's required. If any of these pieces of information are not on the card, you will be subject to DOS discipline. The business card address, the business address, and that's the address of the brokerage firm. So only the addresses that are listed with the DOS as a valid address that's registered with the DOS under the brokerage firm can be shown on the business card. If you have a branch office, if you have a home office, unless it's registered, you can't show it on the card. It has to show the broker's address. And that needs to be reflected, and that has to be with, obviously with the brokerage firm that your licensee, that your license is associated with the DOS. Teams utilizing business cards must fully comply as if you're not a team. So whatever applies to the individual will apply exactly to the team. There's no difference. So when you're going through the regs and you're going through the material that I've sent you, obviously you got to just make sure that, take the team aside. If it's valid for the person, it'll be valid for the team. If it's invalid for the person, obviously it would be invalid for the team. If your name is Jonathan and you want to go by nickname John, I see this a lot, and I've seen actually the DOS discipline for this. I've seen where person's name is Margaret, she goes by Peggy, okay? And if the card says Peggy, the DOS license, if it's registered as Margaret, you're going to get a fine. You're going to get disciplined. You may not lose the license because they really hold that for strict disciplinary issues. But obviously there will be fines imposed, and the more you get, the more violations, the more the DOS will go back into the history and see how many violations a particular agent has gotten. So you got to just be careful. So if you have, a nickname, if it's John or Jonathan, just make sure that you have either John in quotes or any other name in quotes. You don't have to register that nickname with the Department of State, but you should have it in quotes. But you have to have, no matter what, as an element on the business card, your name, the full name as it's written on your pocket card. Again, if you follow the DOS's best practices, whatever your license type is, this is another issue. A lot of times you just want to put sales associate or real estate agent. You have to follow exactly what the DOS has on record. So if you're a licensed sales associate, that's what you put on your license. Licensed real estate broker, that's what you put on your license. We'll get into some titles and stuff later on, but basically you just have to be wary of these issues. Signs. Signs are another important element. These are just, and again, you may know all of this stuff. This is just really a refresher course in what you do know. If you don't know it, it's obviously new information, and you should, make sure that you're aware of the regulations. Unless a local law provides otherwise, any signage placed on a property must identify the representative broker or brokerage firm. So obviously, if there's teams, you got to make sure the brokerage firm is on that sign. In the materials, it says signs. for sale signs. I just omitted to put for sale signs, but for sale signs are not required to include the address or phone number of the broker, okay? So basically, and the reg 175.25 is very clear. You can, refer to it. It's in the materials, and it tells you exactly what you can do and you can't do. However, if the sign is going to include phone numbers, so if you are going to put a phone number on a sign or a particular sign, that of the brokerage or any advertisement for that matter, you must identify the type of the phone number that it is, whether it's an office number, whether it's a cell number. You actually have to denote preface those numbers by either cell, office, work, home, whatever it is. Directional signs for open houses, they are not required to include the name, address, or telephone number of the brokerage firm. But again, if you do include it, then obviously the other sign regulations that I've just pointed out do apply. So anytime you include additional information, you have to comply with the regs. So basically, if you're having an open house, you can just basically have either the brokerage firm name with, a directional sign, an arrow saying open house, this way. If a licensee includes his or her name or a team name on a directional sign, then again, the brokerage firm must be listed. So if you have for sale signs, it's probably going to just say the Keller Williams, the name of the brokerage firm, Hudson Valley, but it's not. If you do anything that has a team name on it or a name, you have to include the brokerage firm first. Trade names, these are usually another issue that we deal with a lot is trade names. Many brokers form an entity under a particular trade name. When you form an entity, whether it's a corporation or an LLC, you're going to name it some name. You're going to name it, 123 Realty, LLC, something to that effect. However, sometimes you want a DBA as a separate name. Usually under the franchise, you're going to DBA as Keller Williams Hudson Valley. You're going to do a lot of different things. Those DBAs have to be approved by the DOS. So if you're going to register any DBA, if you're going to have a corporate name, make sure that the license is also submitted under the DBA so that the DOS, you will get fined. And a lot of times, the fine doesn't come up because you don't comply with this. The fine comes up because you're going to get either a grievance, complaint filed with the DOS. The DOS investigated officer usually will send me a checklist as the attorney. A lot of the brokers will contact me and then say, what do we do? And there's a huge checklist of items that the investigator wants. And some of those items are going to be the names of, whether they want a business certificate or an incorporation. They want to make sure, the section 443 has been given. So they'll give me a list of information, and they'll look at all that information and not only focus on what the complaint is focusing on, they'll also issue additional violations at the same time. So they're not going to limit it to what the complaint is, but they'll also find if they see that your business card is wrong or they see that you're not filing under a DBA and the DBA is not approved, obviously you'll have additional ramifications and violations there as well. It's not a new requirement. Okay, any doing business as, you should have the corporate name and also the DBA name followed by it. It's not new, this has always been there. Brokerage firms are only permitted to advertise under the name that appears under the DOS license and registration. If a corporation or LLC operates under an assumed name, then you have to file, again, to obtain a license under that assumed name. Every salesperson licensed with the firm must also be licensed under the assumed name. So again, if you're licensed and you're a salesperson, you have to be licensed as well when you're filling out the salesperson application, that it designates the DBA as well. And again, DOS investigators usually are looking at this stuff. They really look at it. I've had a lot of investigators that I deal with. We're focusing on one complaint, and all of a sudden they call me and say, John, there's a ton of other things wrong with this issue that have nothing to do with it, and then we have to address those issues as well. In the end, we normally, hopefully, don't go to trial. We don't have to meet the administrative law judge. We can try to settle it with the with the senior attorneys there at the DOS, but it's something that you have to always keep in the back of your mind. And again, any entities, you just have to make sure you're operating in accordance with the law. So if you have any questions or you feel like you're not, obviously you direct them to the correct personnel in the firm and make sure that they, if they don't know the answer, certainly will provide, the information that you need. So again, if you go through the materials, I'm just going to go quickly through Reg 175.25 just to say they have the definition of advertising, they have a definition of teams. I'll get back to this later, but the definition of teams in here is a reg. There's actually no definition in the real property law, which is kind of weird. When the DOS instituted the name, the definition of a team, they did not change or amend the real property law to include the same definition. I'll touch upon that later on, but there's a definition of what team is, what the real estate brokerage means, and then basically it goes through and it really outlines exactly what you need to do. It has placement of advertisements. 175.25 is very well written, pretty clear to follow. Placement of only a real estate broker is permitted to place a sign, to be published advertising relating to the sale of real property. That's right out of the statute, out of the regulation. Advertisements placed or caused to be published by an associate real estate broker, real estate salesperson, or a team listed with or represented by the real estate broker are not permitted except where the property is listed with or represented by the real estate broker with whom the associate real estate broker, the licensed real estate salesperson, or the team is placing the ad. So you have to make sure that we follow this. You have authorization also for advertising. No property shall be advertised without the express written consent of the seller or the owner of the property. And real estate brokers shall not advertise property that is subject to an exclusive listing held by another real estate broker without the permission of the listing broker. So those are just some, tidbits of information. Some of the contents of advertising: name of the real estate broker, name of the associated licensees. These are all different subjects under the 175.25. And again, it's part of your materials. It's not in the bullet point here on the presentation. Nicknames. These are all just some of the things that I've touched upon. The license type, you need to be express. Contact information has to be in compliance with the reg. Again, home offices. The only time you can have a home office is if it's registered with the DOS as a home office or a branch office. You can't have that on your card, basically saying that you have a home office, because you're misrepresenting and it could lead to a DOS disciplinary action against you. Telephone numbers, again, we went through that. Logos. If the team has a logo and you want to show it, you still have to show the brokerage firm logo as well. If the team does not have a logo, you have to show the brokerage firm logo. So that's basically just a quick thing to think about, to go back to your business cards, flyers, whatever ads you have out there, you got to make sure they're really compliant with these types of regs. I know it's a lot of information to take in, but again, this is stuff that, is evolving. We have some new brokers here, older brokers, and believe me, some of the older brokers don't know, a lot of the stuff either, and they'll come to me and call me and say, John, what do we do? And that's basically, what we outlined there. Again, there's articles that Ed has written, that I have written. I've made them part of the materials. One of the articles that are included in the materials is entitled Business Cards and Signs. If you want to use that, that's basically an outline on what to do and what you need to refer to when you're basically figuring out what you can include on a business card. Again, some of the highlights, the advertisements must include the name of the real estate broker or the brokerage firm. Advertisements must reflect the name of the license status under the DOS, nicknames, all that type of stuff. It's all included in the article. And I use it, you'd be surprised, a lot of times broker or an agent will call and say, John, what do I do? I'll send them the articles we wrote. And then by the time they read it, they're like, great, I know exactly what to do. So it's kind of a good resource. I would, encourage everyone when you get the Real Estate in Depth or any of the real estate, there are a lot of very valuable articles in there, especially the NYSAR Legal Lines has a lot of valuable information, and they keep up. So, a lot of this stuff is really all legal related, and obviously we try to write in a way where everybody understands it so it's not, really over your head. And again, there's also an answer published by Anthony Gatto up at NYSAR. He's NYSAR's in-house legal counsel, general counsel there. And basically there's a question and answer, a Q&A form that he's handed out. And usually they answer pretty much all of the questions. Some of them, can my broker have a different advertising requirements other than those found in the regulations? He provides a pretty straight, yeah.
I just want to state that everything that John is saying, all the materials here are a great guide. But you have to remember that everything that you do, whether it's a business card, a sign, an ad, must go through our compliance. Okay, so we have our compliance maven in New City, Diane Carroll, who she needs to see all of your advertising. Yes, give Diane a big round of applause because she keeps you guys in line. And in Middletown and Rock Hill, it has to go through Erin there. So right now, so.
Yeah, again, and just to stress, nothing in here, obviously, all has to be approved by the brokerage firm. Okay, so no advertisement, no business cards, can be done anyway. So I think we lost.
Yeah, Maureen will come up in a minute.
Okay.
She'll get you on.
I think we got it back on. Let's see if I got this.
She'll get you back.
Yeah. So we'll keep going. So that's basically, in a nutshell, some advertising, some tidbits on advertising. Okay. We also have trade names. Again, we went over those. Let's go over those as well quickly. So many, again, many brokers form an entity under a particular name and have and then do business. In the context, just so you know, we have. We did all of the trade names. I just forgot to go ahead on the slide. So let's go. So after that section, I'm going to open it up to some questions. If anyone has any questions.
Anybody with questions? Good.
I have one question. Where are all the handouts you're referring to? Are they in this 300-page document somewhere?
Yes, yes. They should, and I think I sent out a revised packet. So if you got an initial packet, Rosemary will send out an updated packet that actually puts the handouts right after each section rather than in order at the end. So it'll be easier. You'll get to the end of the sections, and when you get the new package, the revised package, all I did was basically just put the handouts right after each section so that it's easier to refer to.
Yeah, I know New City got the revised yesterday. I'm not sure if Oh, okay, you didn't. So Middletown and Rock Hill, you will get the revised package.
Yeah, for purposes of today, you don't really need to go through the materials, but they are all there. They're all available. The only one article that I did not include in the package, which I just, I'll email separately, is just an article that I wrote on the lead paint. Lead paint, as we all know it, there hasn't been really a huge change. But I'm also going to email that. It's a legal line article that I wrote back in 2008 and really outlines the procedures and what we need to know about, lead paint disclosures. So we'll get to that when we get to that section.
Here, Anthony.
Here you're not referring to, John, when somebody forms an LLC or an S Corp to get paid from the broker.
Yeah, we're not talking about that here.
Thank you.
Okay.
Somebody else
Fred Miller.
Let's say the DOS investigator finds something that is wrong. What is a typical fine? And then also, does errors and omissions insurance cover that?
Good question. I can tell you errors and omissions will cover it. Whether the brokerage firm wants to put in a claim on the errors and omissions policy is a different story. Rosemary, I think, has a little comment to that, and then I'll get to the legal.
So, I've been a broker for 20 years. Kudos to all of you, because we have only had a handful of complaints to the DOS, like less than 5 in 20 years. Okay? We have only had 1 fair housing complaint, and we have only had 1 arbitration in the Board of Realtors. And all of those were not found to be in any way finable or our offense. Okay? So what I can tell you is we've never had to deal with that, and I hope I never do have to deal with it. But we do also have a $2,500 deductible. Okay? So in our P&G, any deductible has to be met by the agent if you're found to be in violation first before we would collect on our E&O insurance. Yes.
Yeah, just from practice.
My question is for Rosemary. If it goes to compliance, whatever, business card, can the agent still be held responsible by?
No, if it goes through our compliance, it won't. But the complaints that we've gotten have been about activities, license activities, things like that. Not so much that a sign wasn't in compliance or things that we're checking. So.
Yeah, and just back on the point of whether, you cover it under D&O. Most D&Os will cover it. Obviously, the deductible they have to take into account. Most of the brokerage firms that we represent will call us and say, we're not going to put in a claim, John, can you just handle it or, deal with it. And normally, if it's not a huge violation, you're dealing with a fine, $250, $500. It's not the end of the world. They basically, if you need to take some additional CE courses, they'll put that into the settlement agreement with the DOS. But for the most part, thank goodness, when they call us and we try to knock it out on the first round, I just got an email yesterday morning where we submitted an answer to the investigative officer. And just so you know, thank God there's only 5, but I have brokerage firms who literally call me almost once a week, and it's bad. But
it better not. It better not.
So we can see
it better not be this firm.
Exactly. We can see, if there's only 5 in the history, that's not bad. But what I can tell you is when they do call, I have to meet with the client, I have to meet with the brokerage firm, with the licensed salesperson, and with the broker or the managing, member of the firm. And then basically what we do is I try to, a lot of times there's emails. The important thing is I'll give you one example that we worked on. They're emails and texts. They're just horrible. I try to tell people they're good in one way, but they're very bad in another. There's just so much information that sometimes the brokers will say, I didn't do anything wrong, and I'll get text messages that go on for weeks and months, and the person has become that person's agent, representing a buyer where normally you wouldn't. You did the email exchange. So I try to look at it, and I try to turn the response in such a way where we just focus on the issues and try to get it kicked out at the investigative level. If you can do that, normally it just gets kicked out. If the investigator sees that there's any additional or can't really make a decision as to one way or the other, it gets bumped up, and it gets bumped up to the attorneys at the DOS. At that point, it gets a lot more involved. The DOS attorneys are going to require a lot more information. And I can tell you, we sent the response in 15 days ago, already got it dismissed on the investigative level. I sent the response in on a horrible fact pattern, and the DOS investigator, who's the same one who dismissed the other one, 2 months later, still not dismissing it. So, you know, you just have to be careful, and that's basically, you know, most of the brokerage firms, they'll just pay us to take care of it. You know, especially the firms who have a lot of, you know, violations and don't run their operations the right way, or, you know, a little lax. The more you put into claims, the higher your E&O is going to go, and the likelihood of you renewing that E&O application, you know, policy next year is going to be, you know, slim to none. So that's just some, you know, and I'm going to try to give you some personal experiences too. It's not just learning this stuff, it's knowing what they actually do. I mean, it's great that we have all of this stuff, but sometimes the DOS, I can tell you, Ed and I, we've met with Whitney Clark. We go up to the NYSAR conferences twice a year. We go out to Chicago once or twice a year, out to San Diego. We meet with all of these people. And a lot of times the DOS investigators don't even know the law. You know, I have to actually pull out letters from Whitney Clark or letters from past, you know, senior attorneys saying, they basically said this was okay, and you're saying it's not, and then they'll go back and they'll retrace their steps and say, okay, fine. I had one instance where the senior attorney said, I don't care what the prior attorney said, this is what it is now, and you have to follow it. So, you know, again, it'll help. It's good that you have that background, but each case is different, and sometimes where you can get a dismissal on one, and on the same fact pattern, you'll get an investigative officer who just won't make a decision and send it up right into the attorney stage. So you just have to be careful. Section 2, we're going to do a little bit of an agency overview. And again, a lot of times people like us and real estate brokers, we forget that we're fiduciaries. You know, and we represent attorneys as well. So attorneys come to us, and Ed was on the grievance committee for many years, was the chairman of the 9th Judicial District Grievance Committee. And a lot of attorneys will come to us because they have a grievance against them. So it's basically along the same lines as grievances and complaints against DOS licensees and brokers. So what happens is basically they'll come to us and say, you know, what did I do wrong? Well, you're an agent, and there's specific duties that agents have. And obviously there's different types of agency, but for the most part, if you're a fiduciary, you're a fiduciary. You and I are held to the highest standard at law. There is no higher standard than to be a fiduciary of your client. And that's what we're held to. So when the DOS sees that you may have had a dual agency situation and did not disclose it, they come down hard on you. Sometimes they'll take the license away. Sometimes the fines will be, you know, hefty. The continuing education requirements will be hefty. But, you know, they don't like fiduciary responsibilities because those responsibilities have not changed. A lot of this law changes every year. I mean, we're up there. NYSAR does a great job. You know, the Hudson Gateway does a great job at, you know, political action and trying to get laws passed or defeated. But sometimes, you know, we forget about the agency and why the agency is out there and why the disclosures are required. These are all required disclosures. They're all right in the law. So when you see that agency disclosure, the buyer and seller disclosure, that actually, if you open up the law book, there's a page in there that shows the disclosure. It's, you know, it's not that the DOS came up with it. This is part of the law. So that form comes out, and we'll, you know, basically under the RPL, and a lot of times it's called a Section 443 disclosure. We need to provide that form to a seller or a landlord prior to entering into a listing agreement. So that's the most important thing. Over the years, the DOS has held first substantive contact. Okay, a few years ago, before the email thing and before the faxes and all of this kind of stuff, there was a real, you know, determination factor on what, you know, made up real, you know, first substantive contact. They came up with this warm body contact. What does that mean? You'll know it when you see it. You know, you're talking to a landlord, you're talking to a seller, they come in, you start, you know, they tell you, we want to retain you, we basically want to sell our property, you get into the nitty-gritty. You know, that's substantive contact. You have a request, what do you guys charge? You know, what do you do on a listing? And it's just an informational request. Obviously, you haven't stepped over that line. With email, texting, that really has warm body doesn't apply anymore. Now it's really fact determinative. If there's emails going back saying, yeah, I'm representing you, and you didn't give a 443 disclosure, you're going to be fined. You may, and I've seen licenses just on text basically taken away because, a client comes in, grieves, says they represented the seller, but they also represented me. And there's a text saying, don't worry, I have your back. I mean, literally, that was one of the questions. I'm taking care of you. If you're not a buyer's agent, you're not taking care of the buyer unless you actually disclose that up front. You have to have this, so I always tend to go onto the conservative side and say, if you're close and you know it, have it signed. Have all of the documentation signed at that time. And again, you go through compliance and make sure. I mean, Rosemary runs, a stellar operation. There's usually not a lot that I have to tell. But when I do the smaller brokerage firms or the, mom and pop type of firms where they have 4 or 5 or 6 agents, I can tell you I do a lot of, representation of brokers in the Bronx and the boroughs. The Bronx has actually gotten very good. And I can tell you why, because they've actually become members of the HGAR, the MLS, and they've become members of the Hudson Gateway. We're not part of them. We don't represent them as an official region, but they are a substantial part. Richard Haggerty reported on Monday at the Women's Council that they make up, we have 700 registered members from the Bronx. I can tell you when I started doing this 20 years ago, the Bronx was the Wild West. 443 disclosures, I don't even think they knew what it was. And they've been around for years. So you have to be careful. Again, this is stuff that you may say, it's second nature, we know what we're doing. But be careful. The person that I told you that we're waiting for the DOS investigator to dismiss it, and hopefully we can, his text messages are not good, And I didn't give any text messages to the DOS investigator, but I did specifically go through and address each of them in the response. If they come back and they want to see them, I made as best an argument as I can to say that he's not. But if they do request it and it goes to the next level, there's really not much I can do. They can subpoena those records. And unfortunately, text messages don't go away when you hit delete, okay? I have a client who called me just the other night. He's getting, not even a grievance, he's getting sued in small claims court for an alleged agreement by the sales agent, basically saying, I'm going to reduce your commission at the closing by $2,000. Obviously, my client says it was never said. There is an email coming from the buyer's agent, from the seller, I apologize, to the selling agent, saying, please confirm, that you're going to give me the $2,000 credit. So there was some sort of communication. So when the broker tells me they didn't talk about it at all, obviously there's something there. So and that's the licensee, the broker, the broker of the firm called me, and basically I told him, I said, listen, he may not see the email, he may not remember he responded to an email, but there may be a response. I mean, everybody's you run around day to day. I'm going to take questions. Go ahead, I'll take a quick one.
In your opinion, is first substantive contact always in person? Always in person?
No. That's why I'm stressing with emails, with phone calls. A lot of times we do stuff, and even myself as an attorney, I engage people through phone, through email. I send engagement letters, via phone and email and fax. So these days, if there's enough information, it's very fact determinative. So it's fact-based. The investigative officer or the attorney at the DOS, or even in court, if this goes to litigation, a lot of times we do side-by-side. We represent the brokerage firm and the broker. But I'm going to get to it. I stray a little bit, but we don't have that much time, and we're going to try to take a break at about 1:45, Rosemary, or
yeah.
Is that good? So yes, it's very fact determinative. Substantive contact isn't the warm body contact standard that was.
Okay, so just piggybacking on that, then, when if you're going back and forth with email, then at what point are you having them sign a disclosure?
It should be as soon as there's talk about listing, price, commission, and that basically we're going with your firm. That's substantive contact. You know, it could be even less than that. And I can't tell you what it is because I've seen DOS attorneys say that there's an agency relationship on even less than what I just said. So it's really, what I suggest is just make sure that that you're very clear when you're dealing with.
I think the bigger question is on the buyer side, okay? When buyers call up and are talking to our agents,